you so much. This is a real privilege to be able to take part. I want to present my project titled Judged by Machines. As you said, I'm working from King's College London in the law school, and my topic is how do algorithms now used in criminal justice making impact on the legitimacy of the system. So my research takes place in an environment which I think of as a policy environment, though it's it's more general than that, no doubt. But we have a justice system with resource issues and massive backlogs in terms of cases being heard. Criminal cases in the UK now can take something like 2 years from their first hearing to actually a trial. So that has massive impacts on justice. We're also very aware of now human fallibility. Obviously have discussions around the area of bias. We know that that humans employ things like heuristics, and we know that logical fallacies are used in courtroom arguments, which can cause problems in terms of justice in themselves. To try and address these sort of things, it would be remiss not to look at things like decision tree algorithms, machine learning algorithms, Bayesian reasoning, and to see how one can improve the situation. And I think it's in a sort of environment of urgency as well. So my research so far, I've conducted a pilot study just between 2019 to 2020, where I conducted a number of interviews, and I observed a kind of construction of a concept in a hackathon, a kind of decision-making tool, and my decision support recommender systems conference in the Turing Institute in London. But my work was basically, I was trying to take this sort of heterogeneous approach, looking at various viewpoints. I spoke to members of the senior judiciary and also computer science, justice campaigners, etc. So I was trying to get this holistic view on which a base to build my research going forward, so that wherever I took this, it would be practical and relevant to whomever, the whole community in a sense. And that's the objective. It's a broad one, but that's what I'm aiming for. And that's just a word cloud, a fairly basic one of the kind of things that came out of those interviews. I think there's a serious resistance to change within the legal community, and they have been, Richard Susskind refers to them, or rather says you can either be a jealous guard of your situation, and protect your self-interest and have a fear of what may happen, or you could, you're a benevolent kind of custodian, you're trying to help, you've got genuine concerns. And the trouble is, how do you unpick what's going on there, and what happens, what I feel is going to happen or must happen, is a kind of forced change that might come through some policy development or otherwise, and I think it's so important that this is done properly. In terms of what my literature that I'm looking at and how I'm trying to build this is, that what I see is a number of internal kind of approaches, and that's not a criticism, it's a strength in the sense that they need to have internal sort of validity. So you have, legal academics and professionals talking within their sphere of legal doctrine. Is it legal to have AI in this circumstance? Can we legislate against it, or how do we limit it? You've got policymakers who have completely potentially different perspectives. They see the need for justice to be, sort of seen to be done as well. And not that that's not a concern of the other scenarios, but it's just it's it's a different discussion that's going on there. And then obviously in the expertise in computing decision making, sort of psychology and in computing, where we're looking at the kind of the mechanics of it. How does it work? So that's a challenge to try and bridge these things. And that's what I'm attempting to do. My concern with the sort of current approach is there's a lack of unified success criteria. I say, what we're talking about in legal ethics or something like that is very different to what is being talked about in other spheres. So, you might have a proxy for something like transparency or legitimacy when you're trying to assess an algorithm, which is very different to how that term is considered in the different internal sphere, like I'm saying, the sort of legal sphere. And this is a trouble, and I think it's something that's been recognised in the conference so far. I watched Stegen et al.'s paper on talking about how we ensure rationales are, it's not just good enough to be sort of accuracy is the thing. And when I'm talking about, I think efficiency is a very important thing, but we need to know what the output per cost of the resources employed is. What are we aiming to achieve with our justice system? We can't be sure that we've adequately got guilt down, that we don't know if our justice system at present is adequately identifying guilt. So learning off those old that old data is a challenge. And there's also this idea of risk, and we had talks this week about the AI, the European perspective on what is high risk and things like that. But I think that we have to have a way of assessing this risk beyond the level of the individual. How do we assess and weigh that? And my argument is the crucial thing is legitimacy here. And this is just very briefly, I've highlighted some ways in which my work overlaps with what's been discussed this week. We're talking, there's a lot of talk about obviously ethical use of AI and the need for the lawyer's perspective to be taken into account. And we know the eternal debates on philosophy, but I think, we need to pull apart the mechanics of the decision-making process in a judicial sense. Where is morality there? Because we're not, it's supposed to all be rule-based. And if we can't pull it apart and understand where it is, that's, then, we have to be able to identify it. It must be there somewhere. So let's find it. But I think generally we're left with a sort of unsatisfactory lack of answers. And I'm proposing the legitimacy answers that. And just to say, explainable AI, I know this is all going through a lot of these discussions that are going on, and I'm not going through all the literature here because I just want to get to what my proposal is. So the way I perceive legitimacy is actually an empirical definition. It comes from Tyler, who's looked into how people perceive legitimacy and how that impacts on their behavior. So we have, if we look at the very bottom box there, the effectiveness of government and success of policies, this is important for all of us. Yeah, so this is a common goal because we want, some kind of stability. Yeah. Well, our humans, it's been shown in empirical research that the voluntary cooperation with the authorities and adherence to the rules of behavior is so crucial for sort of, social coherence, etc., is based to a striking degree on the quality of the treatment that they receive and the quality of decision making that they perceive in the justice system itself. And I think crucially, this metric's not limited to algorithms or AI. This is a metric that can be used for the current justice. In fact, that's what it's traditionally been used for. And it can be now applied to the, the sphere of algorithms coming into the justice system. And what I try to propose here is a kind of systematic way in which we can take into account humans' perception of how these tools may work, how they, as well as their, sort of effectiveness, in a way that is sort of makes all our goals, together. It doesn't matter which of those three columns, or whether you're in the computer science or the legal ethics or whatever, that we can work towards the same thing. Yes, and exactly, it works with the idea of we've got failures in engagement at the moment, and it's just so crucial that we find a way forward. So my proposal is a systematic approach, and my method, which I will go through shortly, is I propose is rigorous. I'm trying to make it rigorous. I'd be so happy if you could tell me a way to make it more rigorous, and it's a hybrid of social science techniques and well, I'm proposing kind of Bayesian legal idioms way of dealing with it. The measure, I've already gone into legitimacy, and that will be measured using Likert scales, a quantitative and a qualitative analysis of that measure. And we're looking at testing it with the public and elite stakeholders. So hopefully this is something could be replicated, could be extended. To narrow the field, I'm choosing two specific cases. Okay, one is a civil affordability calculator, very basic decision tree algorithm, which will look at how much do you earn, how much is your expenditure, can you afford to pay this fine? Okay, now this is something traditionally done manually. It's in the online courts pilot in the UK. It's been put into an algorithm, very basic, should be relatively innocuous. And then a traffic offence, which I've chosen as being another basic, relatively basic offence, but a bit more complex. And with that offence, there's no existing algorithm, but I want to build a model using advanced qualitative techniques and this concept of legal idioms. Once I've created the stimuli, which I can then expose people to, I want to test those processes through online testing. So using a recognized behavioral science platform, which tests people's responses to various things, I've been testing, trying out ways of getting things on there that I can then measure people's reactions, and I will follow that with qualitative interviews and focus groups. So the single justice procedure, which is the basic traffic offence that I'm looking at, it's a very simple process at the moment. It's the most sort of straightforward. It's dealt with one magistrate, and it goes from a letter saying you've been accused of this offence. It goes through to if nobody responds, then you're found more or less automatically guilty. There is the potential for a magistrate to intervene, but I think in practice, at least, it seems that that's rare, and this was something obviously I will develop through the case study, the rarity of this element. And then if one says you're guilty, you may, or you're guilty with mitigation, but you don't request a hearing, it's done all on the papers. And it's only if one says not guilty, then it goes to a hearing. So I think it's interesting, it's worth looking into. The other one I've already explained is just a very basic decision tree algorithm. And I see these two case studies as overlapping, that they can expose through their overlapping elements and their sort of differences, a rich kind of landscape of how legitimacy can be impacted with various types. So what I'm really trying to do is say, like, how can we unpick in policy terms, well, not just in policy terms, but generally, how can we unpick, is it right, or is it right is a bit of a term, but is it profitable? Is it the right thing to do in sense of effectiveness of the justice system for you to introduce a particular type of algorithm? And I'm trying to unpick different types of algorithms in that sense. So just want to explain as well my data collection process. The two case study approach, the first stage of that is a kind of building stage, I'm going to use my doctrinal analysis, which the basic kind of legal analysis of the offence, to analyze this basic traffic offence, which is a signage, failure to adhere to a traffic sign. I'm also going to try and observe a short period of observation in magistrate's court. That's only brief because I have experience in magistrate court, so I don't need to observe that much, but just to ground it in some reality. And then I will be interviewing court staff, legal advisors. The purpose of this first stage is not to try and gather qualitative data. It is to create a model. Yeah, so that's the first stage. And then the second, so I'll then, I'm backing and I'm then developing that with colleagues in computer science. The second case is the affordability calculator. That's much more straightforward. And I will, once I've developed the stimulus, that I want to expose people to online, then I will put those two onto Gorilla, the platform, the behavioral science platform, and, follow that up with, once I've harvested the data from the responses, the clicked responses that we'll get there, also follow that up with focus groups and semi-structured interviews. Now, I'm really interested in any comments on everything, but this especially, when I've gone into advanced qualitative social science methods, I know I've seen that there's cause, they're very interested in causal relationships, of course, and the kind of diagrams and interrelationships that I feel that they're creating in those kinds of analyses are, I think, analogous to the same process that we see, or the reasoning that we see in Bayesian methods and Bayesian things like the legal idioms that Fenton and Neal, for example, have set out. So I've had a go. This is Fenton and Neal's example. I've had a go at doing one on the basis of doctrinal analysis alone. But the point is I'm going to use the interviews, use social science methods to create, to then take all this information, this sort of structure, this causal structure, and place it into, sort of then translate it into this sort of legal idioms kind of thing. And that's going to be a process I'll go over in the building stage. Then back to my data collection process, I move on to the testing. And the testing stage, I'm looking at quantitative data. I've already covered this, but identifying different responses, etc. And I see it as a starting point for further research. This is something that I could expand. And I'm looking at trying to communicate with policymakers and, well, the whole community, very much, Jake, I think, was very, very interesting discussion about the need for various viewpoints. And I absolutely agree. And there's no voice that should be ignored in that sense. And I think this is a way of potentially showing people how we could do that, and how we can make sure that voices are heard. This is an empirical measure that I'm trying to do. It's not one perspective. Terms like trust, rule of law, respect, they have different meanings from different viewpoints. But this legitimacy, this definition, is empirically measurable. It's something we've got a scale. We know that links to people's adherence to the rule of, or to law, and their cooperation, which are absolutely foundational to how our legal system works. So I see it as a very interesting and an important way of dealing with it. And yeah, I just said my last point there is just linking it to previous discussions I've heard this week. The last thing I want to discuss, and it's just, I feel I want to just explain this complex building analogy, which I think is a way of understanding why the approach that I suggest I see as important and crucial. I don't think it's an arduous thing, and I'm arguing this to my colleagues in social science, in law. I don't think it's an arduous thing to go from this descriptive, let's see what everybody is doing at the moment kind of situation, and to go from that to the Bayesian causal relationships, I think it's natural and necessary. I think in using, we're not just describing, we're creating a model, and I think those two things are intrinsically linked. The complex building analogy comes from Gawande, and it's in the checklist manifesto, where he discusses how important it is, just like Jake says, actually, that we're looking at everyone in that environment contributing to what's happening. Because if you think about a situation where you've got a team, and he describes a team of he describes a team in a surgical, because he's a medic, he's in medicine. And he says how important is that the nurse or the person handing the scalpel or whatever, that they are heard and they have a place in that discussion. And it's integral to the actual success of the whole exercise. Yeah. So it's not a nice to have, let's have a nice ethical thing where we have nice people, it's just, no, it's integral to the success of the ultimate objective. And I think this is the crucial thing. Gawande also talks about making reliable management of complexity a routine. And we have an incredibly complex scenario here. The justice system has many experts. You have to integrate with experts from other fields, computer science fields and things like that. And when we think about construction of large buildings, we used to have this idea of the master builder who would they'd design it, they'd be the architect, they would then create, they'd oversee the actual thing. If someone wants to put a pipe in there, he'll check that it's okay, because it would have been a he most of the time. And he would, or want to put some electrics there, he would check that that's structurally right, or we want to knock a wall through there, he would check. That's not how construction is done right now. What we have is, various schematics, various things where we're trying to integrate different expertise. No one expertise is overseeing. And I see legitimacy as this structural integrity of the justice system. The main thing is we don't want the building to fall down. This is our unified goal. And by using this rigorous way of looking at it, we can make this management of complexity a routine. We can make saying, right, we're going to introduce an algorithm now to help this judge make a decision. It won't be, maybe it will totally replace it, maybe it won't. Maybe it's administrative only, maybe it isn't, maybe it's substantive. We need a way of answering how we interpret those, sort of interventions, and it can't be one person. We have to have a structure and a method. And I think, well, I'm going to try and see if this is a method that will work. And in the process, even if it doesn't work, there's a massive, I'm exploring how, these kinds of algorithms can help. I'm exploring how these different stakeholders can contribute what they experience in it. And I'm exploring how the public in sort of focus groups responds to algorithms being involved in justice in various scenarios. Yes, it's a high risk possibility. That's what I think there is a, we're talking about high risk elements in AI, and I think this could be high risk. Of course it can be, just as anything, let's just in a building knock down that wall. It might be easy and it might be improving, or it might be a bearing wall and cause serious issues. There's no way we can know that holistically without this interaction of people at every stage and every level. And the method I describe is trying to see if this is something we could say, right, this is how we test, this is how we ensure, and it should be an ongoing process. I think it facilitates.
Ms. Hyde, excuse me, you have 5 minutes left.
Okay, I'm more or less finishing, and I'm but I have other slides I can discuss, but I just thought I'll keep it relatively short, because I'm so interested in contributions and feedback from everybody. But yes, if we can, I'm hoping that this exploration actually facilitates. It doesn't, I'm not trying to close any doors and say there's no need for AI here, or here's a line we shall not cross. You know, I mean, I don't think anybody can say that, because that's often from one perspective. Yeah. So I think we say, well, we can't cross that line because we're in a situation where, you know, where it's just the payoff is not enough. But let's look at what's happening right now in terms of justice. It's just not happening. We're not getting justice. Lots of people are not getting justice. So if we talk about bias, we've got the counter argument. If you say bias in algorithms, there's bias in human reasoning. And when you have that interaction between two people, you know, sort of this situation where, well, we need a human overseeing it, or it's okay if we have a human check that what the algorithm says is true. Well, there's so many issues with that I'm not going to go into right now. But the point is, who decides when that overruling is right or not right? Again, we need a structure for this kind of discussion, and the structure is what I propose, and hopefully it will be an interesting journey. Okay, so I think that's all for me for now. And I'm I'd be really grateful. I also wanted to thank the reviewers who looked at my paper. I'm so grateful, because I so want to communicate in this field, and I'm very grateful for pointers on how to be a better communicator in this situation. So thank you very much.
Thank you very much for your presentation, Ms. Hyde. The first question that we have is from Professor Mikal itself. And Professor Mikal sent in the chat, and is in connection with one of the previous talks. I'm interested in your opinion on the relevance of constitutional constraints that may have bearing on the application of your results.
Okay, so there's a reason that I don't look into constitutional law in great depth in this, and it's not because I'm not interested in constitutional law. I've done a lot of work in constitutional law. But in the UK, we don't have a written constitution. We have a political scenario where it's actually obviously possible to introduce whatever, basically, if the particular political will is there, then I don't see constitutional rules preventing the introduction of any algorithms in any scenario, really. I mean, it might sound extreme, but it's from experience in the British legal system. Things are flexible, you know, and therefore I think it's an important, it's not that I'm ignoring that side, but it is still an internal legal discussion. So it's crucial in the sense of what is right, and is this, you know, and there'll be a lot of arguments there that will contribute to you know, to that structural integrity idea, you know. And it's not that I'm trying to in any way undermine that, not at all. I see all of these views as incredibly important, but when I'm looking at what I'm trying to measure here and how I'm going to take the process forward, I didn't think it was wise to restrain myself by constitutional law, you know, sort of saying, well, this is not going to happen because the constitutional law will not allow it. Because in Britain, we don't have that written constitution. We don't have a limit in that sense. So that if political will was that, you know, we want to fully automate this particular process, yes, there'd be very big objections from many sides, but legally it could still happen. So that's why it's sort of more of a contributing rather than an underlying foundational thing.
Okay, our second question is from André Eller, and it is, on your abstract, you affirm that there are serious questions regarding the legitimacy of human-only judicial decision-making. Could you explain it a little?
Of course, yeah. So I think there have been studies that have shown, I think it's the Danzinger, apologies if I'm not pronouncing it correctly, study that shows that, you know, or at least purports to show that there's variation in how judges will make certain decisions based on their, whether they've had lunch, whether they've eaten recently. And that, I mean, that is a measurable effect. It does occur in terms of reduction of the ability to, it's a sort of lack of glucose equals what's the word? Sort of reticence in making particular risky decisions. Yeah, so it's a kind of it's a measured effect. Whether it's as extreme as it's shown in that particular study is questionable. Oh, it has been questioned. But that aside, so you have, do judges make decisions like this, arbitrarily based on that? That's clear. That's a clear query and an important one. We have situations where prosecutions, etc., are based on evidence that doesn't necessarily add up. So you have, like, the situation where, say, the prosecution is arguing, so these three things add to the guilt of this person, or the likely idea that this person has committed this offence. Yeah, he works really nearby. He was seen, walking around there, and he lives within 50 yards. Those three things, they don't add to each other. They're all, because he lives nearby, it's more likely that he's going to be in the area, because and I think the trouble is that there's a lack of rigor sometimes in judicial decision making and jury decision making, etc., which is getting louder and louder. This problem is getting it was a time where we weren't looking into this, and in fact, using the fact that we can do things like predict outcomes of court cases and things like that, that's not going to give us, well, I don't feel that's not going to give us necessarily justice, but the point is it exposes sometimes problems that were not exposed before. So we have a situation where, like, we know, well, why is it that 79% of the cases, are based on the facts, and what about the other 21% of the cases then? And this is coming from the Electra et al. Study, but it's these sort of things which expose potential for people to say, well, actually, what are the judges doing? They don't actually know how to do it, and you obviously have biases as well, which we're well aware of. So I think that there's a strong argument to say it's actually wrong not to use the machines. It's wrong not to get them involved, not to use the things that are there to help us to address these biases, these heuristics that we're using that are improper at times, and ensure that we're actually getting real justice. So that's where I was coming from on that one.
Okay, so thank you so much, Ms. Hyde, for your presentation. It was very clarifying. And now we are going to move on, and I would like to introduce Mr. Kartik Chabla, who will present his paper with the title of Transactions on Privacy and the Tools that Assist in Interdisciplinary Analysis. Mr. Chabla, you have 30 minutes of speech and 30 minutes also